So, Dave, what is with the D.C. Circuit Court of Appeals saying you don't have 45 days to file your petition with the, for an en banc full appeals court review, and you don't have 90 days after that to go to the high court. You have until Monday. This ruling just came out yesterday. They say you have until Monday to appeal to the U.S. Supreme Court.
Well, Jack Smith asked for the expedited review, and I think this decision is part of that. The D.C. Circuit Court of Appeals granted the expedited review. And then on my side of the aisle, people were so frustrated with this court because it looked like they were dragging their feet. And then they came out with this very thorough, powerful ruling, and now they're putting it on the fast track. So I understand where Mike is coming from. If you look at it and say, hey, why speed it up now? But those judges know reality like the rest of us. They know that Trump's legal strategy is to delay this past the election, where you would not have a trial and then Trump gets elected very possibly and then, dismisses the attorney general and Jack Smith, and that's the end of that. So for the interest of justice and the rule of law, they're saying, let's get this decided as soon as possible. But, despite all that, the Supreme Court can still drag its feet and delay it and prevent this from being heard before the election. So this is not the end.
Well, we'll get to that in 1 second, what the Supreme Court's going to do. But I kind of feel like we have an admission there that it was a political decision to get this thing fast-tracked up to SCOTUS by the D.C. Circuit Court of Appeals. And I realize that we have at least one Republican-appointed judge on that 3-judge panel, H.W. Bush. I don't know what that tells us. That's not necessarily what I think of when I think of like a MAGA pro-Trump judge. So I don't know, but I'm sure Trump's not happy about this expedited process. He doesn't want till Monday. He wants 45 days to go to the full D.C. Circuit, and then his 90 days to file before SCOTUS, and then to drag that out and wait for an opinion that won't come until June probably. And let's say he loses in June. By that point, it's going to be really hard to put the pedal down so fast in that January 6th federal trial that it gets resolved before August. That was his plan. But now it's on a fast track. And you raised something, Dave, that I wanted to raise. The outcry from many, respected legal scholars, some less respected, on the left, that the D.C. Circuit, this 3-judge panel, was taking forever, in their view, to issue a ruling on whether he had immunity or he didn't have immunity. We just pulled a little sampling of some of the hysterics that I was listening to. Like, my God, people need to calm down. Take a listen here in SOT 1, MSNBC.
I am officially now at the freakout stage. I can't imagine a more compelling need for speed than the idea that American citizens deserve to know before the election whether a candidate for office is a felon and an insurrectionist.
Neil and I are in violent agreement.
So that was Weissman at the end there, Andrew Weissman and Neil Katyal, former Solicitor General under Obama, there before him. So they were freaked out, and I think it's fair to say, Mike, that the judges who just ruled that everything has to be filed by Monday, and you have to skip the en banc, may have been feeling some of that pressure.
I mean, what a dumb and dangerous partisan argument to make, that you have to have a criminal trial before an election because you apparently these are political forums for the voters to decide the election, these federal courts. That is the stupidest argument I've heard. And you're making Trump rush to file a petition with the Supreme Court on Monday when they know that he has this Thursday oral argument with the Supreme Court. Why are they trying to jam him up? Why are they ignoring normal rules and procedures for every other party except for Trump? They keep saying this mantra that Trump's not above the law. Well, he's not below the law. And why are they treating him like he's below the law? This is an important constitutional issue. This is a critically important constitutional issue. When the Supreme Court decided the issue of civil immunity for presidents of the United States, it took almost 2 years for that to happen. So why do they think that they need to rush and decide this issue in 30 days before the Supreme Court, other than the fact that these Democrats want Jack Smith to try President Trump in D.C. in front of this D.C. Obama judge, Tanya Chutkan, and this 95% Trump deranged D.C. jury pool, and convict him before the election because they know that's the one way that President Trump could lose.
If the high court were to rule that Trump does have immunity, if they take the appeal, which is a big question. I know you've got your doubts, Dave, but if they take the appeal and they rule he is immune, we disagree with the 3-judge panel. Do all the cases go away?
It depends on the scope of the opinion. If they say that he's immune for everything he did while he's president, then a lot of those charges would go away, but not the Mar-a-Lago documents case, because that happened after he left the White House.
Yeah.
And you could say the New York case wouldn't go away because that happened before he entered the White House, the Stormy Daniels hush money payments. But the Jack Smith case would be gutted. And the Fonnie Willis case would not entirely go away because some of the actions took place after he was out, but most of it would. So, yeah, it would gut at least 2 of the cases against him.
Okay, so now that's the question. So I think we all agree Trump will file his appeal with SCOTUS on Monday. He's not going to waive his appeal. And what are the odds they'll take it? Mike, I'll ask you that one first because I kind of teased what Dave's position is. But what do you think SCOTUS is going to take it?
Well, what I think Trump should do is file a motion to stay the proceedings with the Supreme Court. And that I think the Supreme Court's going to grant that, because I think the Supreme Court is going to resent the political games that this panel, this DC Circuit panel, is playing, where they're trying to put a burning bag of political manure on the Supreme Court's step, right? So I think the Supreme Court will issue a stay of all these proceedings pending President Trump's...
Just the trial court. When you say all these proceedings, you're saying stay the trial court federal
Yes.
case against Trump until it can weigh in, the Supreme Court.
Well, and I actually think the Supreme Court is going to say we're going to stay these proceedings so Trump can file his petition for rehearing en banc with the DC Circuit. And then if they deny that, then Trump can file his petition for cert with the Supreme Court of the United States. The bottom line is even if the Supreme Court grants Trump's petition for cert immediately, they're not going to hear this case before the election anyway, because they have cases before Trump's case that are already piled up on the docket. You're not going to get a resolution by the Supreme Court of this case before the presidential election.
Really? Why do you think that? I mean, wouldn't they give it at least expedited review? And they have, it's February now. They have till June. This seems like one of those you might want to squeeze into the docket and make some time for.
Why would they have to rush this case before June? What's the urgency of this case other than election interference, right? And that's the point. The DC Circuit is trying to rush this case, and they're playing political games to interfere in the election. It does not matter whether President Trump is convicted or not. He can still be the president of the United States. There is no reason that the Supreme Court needs to rush this immunity case, and it is an important case. They did not rush the civil immunity case back in 1981. Again, that took almost 2 years for the Supreme Court to resolve. Why would they rush this case?
The pressure to conform to political correctness has undeniably suppressed genuine debate, and it's time we put a stop to it. Enter Freedom 2.0, the unapologetic bottled water company that proudly supports the freedom to speak, freedom to think, and the freedom to listen. We can't afford to remain silent anymore. It's crucial to make our support for the First Amendment crystal clear. And one impactful way to do so is by choosing products from companies that champion our values. Visit freedom20.com and use the code MK for a 15% discount to stand with me and millions of other Americans in celebrating the right to free speech. Remember, freedom is not inherited. It's something we must actively fight for. So raise your voice, grab your bottle of Freedom 2.0 and make a statement. Cheers to Freedom 2.0. That's Freedom 2, the letter O, not Freedom 20, and champion the power of free speech. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.